Good morning to all of you, ladies and gentlemen. Thank you for taking time to be with us today, and welcome to our third in-house Counsel Forum program. My name is Raj Panchmatia, and I'm a partner in Khaitan & Company's Dispute Resolution Practice Group. I would like to extend a warm welcome to this webinar to every one of you, whether you are in our audience in India or around the world. In-house Counsel Forum is a new program from Khaitan & Company, introduced this year following the great success of firm's virtual M&A program held over the last 2 years. The program is designed to be a private educational and discussion forum tailored for in-house counsel teams in India. The intention is to provide bespoke professional training and education not only in the substantive law, but also in management and other topics of interest to the in-house counsel. The forum is private in the sense the participation is by invitation only and not open to public at large. We issue invitations by emails to general counsels, chief legal officers, and the senior in-house counsels in clients and close associates of the firm. And those invitations are also extended to the in-house counsel teams. We hope through this process to provide continuous legal training and education to in-house teams and on matters of interest to them and their companies. On the slide is the agenda for the webinar today. In short, the format will be discussions with our 3 expert panel members, followed by a Q&A session with the audience questions. We hope that the session will be interactive and invite you to ask questions during the webinar as issue arises. We've already received several audience questions. If you have a question, please submit the question using facility in the webinar portal. If we cannot cover all questions during the webinar, we will respond offline by email after the webinar is over. Also, please note that summary of the notes of the webinar will be sent to every member of the registration. In India today, arbitration is by far one of the popular dispute resolution mechanisms, especially for the commercial disputes. Its advantages are many. Despite that, you will see that there is still a significant lack of awareness in relation to the dispute resolution process and arbitration. 2 primary reasons which we see because of which this happens is: one, there is rapidly evolving law applicable to arbitration in India. The law keeps evolving and has evolved continuously over the last 4 or 5 years. Second, no company wants to talk about litigation. I think it's important that we start talking litigation and arbitration. And that's one of the reasons that people don't have the significant understanding of the arbitration law. Again, at a pre-contract stage, if you were to discuss about arbitration or discuss about arbitration clauses, it's like elephant in the room, and nobody wants to discuss about it. Once an arbitration starts, an arbitral tribunal is appointed, the process tends to move quickly, especially post the 2015 and 2019 amendments. The process has actually hastened quite a bit, and you can see that from the commencement to the conclusion, the arbitration process is pretty streamlined and runs very, very quickly. And therefore, it is very important for us lawyers, whether as external advisors or as a part of in-house teams, to start thinking about the process very early. But how early is the question? Our expert panels today, based on their vast experience in the field of arbitration, will answer this important question and also talk about the risks of not having our thoughts and strategies in place and documents in place in advance. For speakers' introduction for today, every person who has registered for this webinar today has already received an email providing credentials of our experts on our panel today. So I will not spend much time repeating or summarizing their credentials. Suffice to say, they are expert arbitration practitioners with vast knowledge and experience in the field of arbitration and have been practicing domestic and international arbitrations for a long time. So without wasting more time, I'll straight away get into our questions with our panelists. My first question would be to Chakrapani. Chakrapani, you've been in the practice for a very long time and you've seen arbitration from very close quarters. Would you agree that sometimes in large transactions, which are fairly complicated and time bound, there are times when not enough thought is put into an arbitration clause while drafting a contract? And a related question to that would be, while drafting an arbitration clause, what are the common mistakes that are made? Chakrapani, to you.
Thank you, Raj. Greetings to everyone, and thank you everyone for taking out time to be with us. So, to answer your question, Raj, it's basically something like this. When a contract is being negotiated or discussed, the entire energy is focused on getting the deal done and documented. What we tend to overlook is that the arbitration is a contract in itself, even though it may be embodied within the document of transaction, it is an agreement in itself. And that leads to some kind of bloopers or some kind of complications which come much later uh, to pour, and then we start facing those difficulties. So, and second part of your question, so what I will do is I will set out some of the bloopers that I can see and which I have seen in my experience over these years, and probably what can be done to avoid them. So let's get started. The first blooper that happens is the scope of the arbitration. When we are putting the arbitration clause, we tend not to focus too much on defining the scope of arbitration. That leads to a lot of complication. So we have this language arising out of, or arising under, or arising in connection with, or dealing with interpretation. Now, all these terms are nuanced. They are all having different meanings. Some may have a little more expanded meaning, some may have narrow meaning. So, given that, it is very important that the scope is very well defined in the clause. That's one blooper that happens, and that can be avoided by carefully thinking through and defining the scope clause. The second part, the second tricky one is the governing law of the arbitration. Now, that gets tied up with the seat, which I'll cover last. But the point is that, again, it's important to know the governing law of the arbitration and it's documented properly. Because having failed to do that, it leads to not only complicated and prolonged litigation, but it also leads to certain uncertain results, which is completely avoidable. So that's another thing that we need to take care of. And especially when it comes to international commercial arbitration, we need to keep in mind the governing law of the seat and also think of where it is going to be implemented, where the award, if passed, will be actually executed. So that needs to be taken care of. Some thought needs to be spent on that so that the bloopers don't come, and when actually a dispute arises, it's all clear in the heads of all the parties. Third thing is the choice of rules. Now, we all have discussed and we all have spoken a lot about valuing the institutional arbitration rules and adopting the institutional arbitration rules and how they streamline the entire process. However, what happens is that if it is not clarified, or a situation where it's an ad hoc arbitration and we try and incorporate certain institutional rule by incorporation. Now, there again, a nuance that needs to be taken care of is that you ensure that you carve out the cost and administrative side of that clause. If you are adopting an international organization's rule into in an ad hoc arbitration, you need to have these carve outs. Otherwise, that can create difficulty. And in my own experience, I have seen couple of arbitrations getting into court process because an institutional arbitration rules in ad hoc arbitration were incorporated, but they failed to carve out that cost and administrative part will not be applicable. So that's again choice of rules. That's something important that needs to be taken care of. Next point would be on the number of appointment of arbitrators. Now, it's a fancy thing to say that, okay, I'll have a 3-member tribunal, 5-member tribunal, but we need to take a step back and we need to think, why do we need that? If the dispute is of a size or of a nature which does not require a 3-member tribunal, we don't need that. We can have a single sole arbitrator appointed. Again, there one care that can be taken if parties agree that there can be a mechanism for appointing a single arbitrator. Because again, in sole arbitrator, in a situation of dispute, parties tend to again litigate on that part as to which sole arbitrator should be appointed. There, if parties have already defined the mechanism to appoint the sole arbitrator, that part can be eliminated. The next point is about a more nuanced arbitration clause, and again, that's coming from experience, where parties tend to define the characteristic of the arbitrator or the qualification of the arbitrator. Nothing wrong with that. A particular kind of contract may require experts. However, when doing so, we need to take two cares. There are two extremes. Either we overqualify, over-specify the qualification of an arbitrator, it may not be possible to find such an arbitrator, and that itself may lead to disputes. Or we leave it very vague, which again will be difficult to fulfill. Another related point there can be that if we have this kind of requirement and we have to specify qualification of the arbitrator, we need to be specific, and as and when such arbitrator gets appointed, ensure that there is a written confirmation from both sides saying confirming the arbitrator's appointment. Otherwise, that may again lead to dispute. So that if these cares are taken in the clause, an arbitration clause can sustain even though it is last minute. Last thing that I wanted to talk about was the seat of arbitration. Now, we all know that the seat of arbitration will determine the procedural law. So, given that, it's very, very important that we choose the law of the seat of arbitration. We choose the seat carefully because that's the law of the seat that will govern the arbitration process. And of course, I'm not getting into the details of the venue versus the seat because that's a topic of another arbitration and another seminar itself. However, it's very important to note that sometimes parties choose a neutral venue, especially when it comes to international commercial arbitrations. Mostly parties choose a neutral venue. But it's important to ensure that enforcement is kept in mind. Because if a neutral venues process is involved, it may create more complications. So choosing the seat of arbitration and the arbitral law governing the arbitration would be very, very important to know. So with this, I think I conclude with my answer to your queries. I'll be happy to take questions later on. Over to you, Raj.
Thank you, Chakapani. I think it is very helpful to give a larger perspective to what you feel and see in the arbitration and where the bloopers are. Coming to that, Sanjeev, it's a very important point which Chakrapani made is about the seat of arbitration, and we all know how important it is to choose the right seat. And many a times we've seen there are confusions. So, do you often see confusions in use of terms seat and venue of arbitration? And if so, what are the consequences? Because I know you had recent experiences on such kind of issues. So maybe, from your experiences, you can probably tell our audience as to what are the consequences of this confusion between seat and venue?
Thank you, Raj, and good morning, good afternoon, and good evening, depending on which part of the world you have joined this webinar from. So let me illustrate this, Raj, from a very live example. We are in the midst of an arbitration wherein it has just started, and we were looking at the arbitration clause, and the arbitration clause says location. It doesn't even say seat or venue, it says location. This is a contract which is essentially an Indian contract arising out of Chennai. The closest nexus of the contract is to Chennai. But the location of arbitration has been agreed by the parties to be Hong Kong. And obviously, we are trying to reach a consensus with the other side as to what location means, whether it means seat or venue, or whether Chennai would be the appropriate kind of a seat. So we have engaged into discussions with the other side, and we are wanting a kind of a clarity as to what can be the seat. But in case we are not able to reach that consensus, then I can assure you next 6 to 8 months would be spent fighting on what the location of arbitration means, whether it means seat, whether it means venue, and whether it's convenience or whether it has got legal connotations or not. So we see that often, and I think the confusion is because in journal local, I would say grammatical English which we use these terms very interchangeably. We use a seat as a venue, a location, place of arbitration very, very interchangeably. But the problem comes in when obviously you have to examine it from a legal lens, and legal connotations are very, very different. As Chakrapani pointed out, a seat would have obviously would define the jurisdiction, supervisory jurisdiction of the courts, which courts would have jurisdiction. It will define curial laws, whereas obviously a venue is only a matter of convenience. Wherever it is convenient for the parties or the arbitral tribunal to hold a hearing, there they'll hold the hearing. I think it's very, very critical and very, very important that seat is always defined as such, because seat is one of the first important things which is required to be determined when obviously an arbitration process starts. And you don't want to be spending first 5 to 6 months of your process in debating. When I said location, whether I meant it to be venue or meant it to be seat. I think, Raj, you are on mute. We are not able to hear you.
I think, thank you, Sanjeev. I think you made a very valid point because many a times we've seen matters going all the way to Supreme Court to decide which is the venue and which is the seat and which law should be made applicable. So it's very important to clarify where the seat of arbitration is. Moving to you, Ajay, I think you've had vast experience with dealing with different general counsels, the legal teams on a regular basis. At what stage of the dispute should legal officers or the legal team in an organization start getting involved with the business teams?
Yes, Raj. Thank you so much. And everyone, hello from our side. See, I will take a step back and I would say that the legal teams, which have really, really evolved over the years, should be involved right even at the stage of documentation. Because there's a lot of experience we have had and we have seen in cases where there are some shortcomings in the agreements where the business teams, and rightly so, they want to move on with the business contracts. They don't want to waste time in getting at times agreements reviewed, etc. So one stage I feel is that the legal teams, in-house legal teams, should get involved at the stage of drafting documents, agreements itself, because the legal teams will be able to appreciate the nuances where something might go wrong and how it can be curbed at that stage itself. Secondly, we have also seen in our experience where some issues have arisen, and even then the legal teams are involved at a far end when things have really gone south. So the view I have is that when you have such solid in-house legal teams as we have now, they should be included, involved right at the inception to at least try to maneuver the manner in which the litigation should run or can run. So in my view, to avoid any further dispute or which something can be curbed, they should definitely be involved first at the stage of agreement drafting itself, and next, if that is not so, when any issue arises for the first time. Thank you.
Thank you. Thank you, Ajay. I think that's very important. So I think it's from what we hear from you is that it's important that the legal teams get involved at the inception along with the business team so that if eventually this matter goes into dispute in any form, the teams are already in place. They know what the background is. Chakrapani, let me come back to you on this. Ajay, you mentioned about the in-house team and in-house lawyers when they should get involved. Now, what are the considerations that should be factored in when forming and engaging an external legal team for an international arbitration? What would you keep in mind? Chakrapani, you are on mute, I think. Chakrapani, you are on mute.
Oh, thank you for that. Sorry. So, as Sanjeev mentioned earlier about the law of the seat, which will govern the process and the substantive law, and Ajay mentioned rightly when counsel should be brought in, etc., and what stage they should be involved. I think my job is a lot easier. I will just put three basic criterion which one needs to look at while bringing in external legal team. And this becomes true both in cases where it is international commercial arbitration, where both parties are in a neutral venue, or it's involving enforcement of awards in India, or it involves enforcement of award elsewhere. So the first important thing is to look at the substantive law and the law of the seat, because the external counsel should not only be well versed with the substantive law, but also should be very well nuanced about the law of the seat, because process and substantive dispute will go hand in hand. So that's one very important factor. The second important factor would be, as I mentioned earlier, that keep enforcement in mind. Ultimately, the entire process is to reach an award which is enforceable, and it should be actually enforced in the jurisdiction where we are looking to enforce. So again, legal team should be familiar with that jurisdiction as well. And the third part is about being sensitive and aware of the culture of, or the cultural, what I call cultural legal nuances of a particular jurisdiction. So if an Indian counsel or Indian party is engaging an external counsel, then it's very important that the external counsel not only is aware of the substantive laws, but also of our tradition and our nuances about certain practices. So these are the criterion that one needs to keep in mind while selecting an external counsel. I'll give an example where let's say the seat of the arbitration is London and substantive law is French. Now, the legal external team not only needs to be very well aware of the procedural laws, but also substantive French law, because otherwise it will create a gap, and otherwise parties will end up having multiple set of counsel. Nothing wrong with that, but as a strategy, if one can find a set of counsel, external counsel who are nuanced in both the procedural and substantive law, that goes very well. So these are the few factors that I suggest one should keep in mind.
Thank you, Chakrapani. I think it's very important to know this as to what are the factors that people keep in mind. Sanjeev, if I may come to you now, how important is it to consult a non-legal expert on technical issues or matters relating to quantification of damages? We've seen today that experts are being used more and more often in arbitration. So, what is your view on this?
So I think the reality is that the businesses are getting complex and very technical. I think they are very, very complex and very, very complicated businesses. You have got disputes which are arising out of launching satellites in space, very complex and complicated kind of an issue. You have kind of disputes in the fields of information technology, wherein obviously it's only the copyrights, etc., which are involved, and an understanding of that is required. So as the businesses are getting very complex and very complicated, I think that kind of pace of development is not keeping with, let's say, the dispute resolution providers, which I will say mostly the arbitrators and lawyers. Arbitrators, and because there are so many kind of disputes and so many kind of businesses, you can't keep pace with all of them, what is happening. You can obviously be an expert in some field of business because you're doing disputes over there, but vast majority will not. And in these kind of disputes, I'm not saying all kind of disputes, but in these kind of disputes, which are very complicated and complex and arising out of complex cases, etc., I would say experts are kind of filling that gap. If you have the right kind of an expert, he can, I would say, dissect a very complex and complicated issue, which is generally not understandable to a layman in very simple layman terms. And I have seen these experts using aids like audio visuals, PowerPoint presentations, etc., to kind of make their point very emphatically and understandable to, let's say, lawyers as well as arbitration, who mostly consists of either retired judges in India or lawyers, let's say, King's counsels and other senior counsels of similar designations in other parts of the world. So I would say that in complex and complicated disputes, they are very important, very critical. We are handling one dispute which relates to a industrial kind of mishap which has happened, and ultimately it's all boiling down as to welding which was done for certain pipe joints, whether that welding was done or had some kind of property or had some kind of latent defects. Obviously, I think you will need experts to explain that, because obviously neither the lawyers nor the arbitrators will understand which are the kind of welding technique, which was the right kind of welding technique for that. Whether that could have been identified in case there were any kind of lacunas or shortcomings, whether those could have been identified with a proper kind of, let's say, expert looking at into it. So I think in these kind of complex disputes, having an expert is very important, very critical, and it can go to it can lead to either you winning or losing an arbitration also. But I wouldn't say that every dispute will require an expert. There would be disputes which would be plain vanilla kind of disputes which really don't require kind of an expert. You are just adding cost in case you are just adding experts to that. So depending upon what is the kind of an issue which is there in the matter to be decided by an arbitral tribunal, whether what is the point of contest, I think if it has got some technical nuances, then I would always advise my clients to get an expert on board.
I think, thank you, Sanjeev, that's very important. The role of experts and when and which kind of matters do you get them involved in? Because as you rightly said, plain vanilla matters you may not need an expert, but complex disputes, complex commercial disputes, shareholders disputes, infrastructure disputes, you may need sometimes a guidance of an expert. That takes me to Ajay. Ajay, at what stage would you recommend that experts be consulted? Would you say that they should come in right at the front, during the disputes, or just to give an expert evidence? What would be your suggestion or advice to the clients?
See, I agree that over the years, the issues and the kind of matters which are coming up are more and more complex. And therefore, from a time when, we used to get evidence from, say, the accounts team of a client to arrive at a conclusion, what is the financial loss? So those days are gone. And over the years, considering the nature of issues which are arising, I would say it is best that when there is any apprehension that a matter will get into the arbitration mode or the litigation mode, you should consult experts because that's what they do. It is their expertise to help clients in calculating the losses, quantum or otherwise, and they have the right skill set and tools to do that. And in high-end, high-stake arbitrations and court cases where we are lucky to have experts available to us, I would advise all in-house legal teams to definitely take advantage of that and try to do that for their matters. And also, at times in our experience, we have seen that sometimes experts are involved only at the stage of evidence, which is something I have not understood really why, because it is at the time of pleadings where you are making a claim. That's where I think you should have the experts on board pre-filing of your statement of claim, for example, so that you are also comforted that what conclusion you have drawn as per the extant laws of the country, wherever you may be. So this part is actually applicable to experts around the world, not only for Indian law, but every law in the world, that when you are drafting a statement of claim, for example, and you lodge a claim, it is advisable to have experts with you at that stage so they can guide you that, look, certain claims are something which you can prove. This is the kind of evidence you might need to establish. And lawyers and experts I have seen should definitely get involved at the start. And that in-house legal, external legal experts, because at the end of the day, it's a team effort where everybody brings their own skill set to achieve a common goal. So I think to answer to that, do that at the first instance, pre-drafting, pre-pleadings. And at times also I have seen when contract managers in a company start issuing letters of small things that, look, as per such and such clause, you are in breach. So here is where we start levying LD, for example. Even those letters may eventually become very relevant during trial. So it's very important that even before you start lodging claims, which is a very done thing for us nowadays with emails and WhatsApps, and all of us on this screen have seen that how certain claims are nowadays lodged on a WhatsApp. Just out of some anguish of the day, people say, okay, you are in breach, here it is, you owe me so much. But that's not how it should run. So in all fairness, the role of in-house legal, external experts, we all have a role to play. So the expert should be brought in when you believe that, yes, we will be lodging claims to this extent, and whether ultimately we'll be able to establish that or not. So it helps. So that's the answer for that. Thank you.
Thank you, Ajay. I think it's very important what you said that, bring in an expert at the right upfront at the time of framing your statement of claim, because that helps you also frame your claim in a manner which can be sustained through the arbitration proceedings. And if it is tested in cross-examination, you're able to justify and establish that claim. So it's important because sometimes if we don't have an expert, we have the tendency to inflate the claims, and maybe we may not be able to justify that kind of claims if we are not able to prove it. So it's important that we bring in experts at the earliest. Sanjeev, as you know, a life cycle of an arbitration starts with invocation of an arbitration notice. Now, how dangerous is it to ignore an arbitration commencement notice that a party may get? In your experience, are there any downside to doing this?
So I would say one of the most important and most critical things in an arbitration is actually who your arbitrator is going to be. And that makes quite a lot of difference, whether it's a sole arbitrator or your arbitrator, you appoint in your arbitration. So therefore, the first notice, which is arbitration commencement notice, under various rules of various arbitral institutions and various laws, including Arbitration and Conciliation Act in India, allows some kind of an ability to have a say in that process, in the process of appointment of an arbitrator. It allows, if it's a sole arbitrator, your views can be considered, and you can have a positive view and a negative view. You can say that I need an arbitrator of a special skill, or you can say I don't need an arbitrator of a certain kind, let's say of a particular nationality where the counterparty is based. And obviously in a 3-member tribunal, you get a chance to appoint at least your nominee arbitrator within that particular time frame. And in case you are not conscious and cognizant of those time frames, that right might be lost for you for all times to come. And I'll just give you an example. There was a SEAC arbitration, and our client came to us after the notice for appointment of their nominee arbitrator had lapsed. And we wrote back to SEAC nominating one arbitrator as our nominee arbitrator, and SEAC came back to us saying, sorry, but your time has been lost. But in that particular case, because the arbitrator was quite a reputable arbitrator, the SEAC was quite they said that though you have lost your chance to appoint an arbitrator, but the name as proposed by you is being appointed by us as your arbitrator. So obviously, which was a good solution for the client, but it might not always happen. The client might have lost the ability to have a nominee arbitrator of his choice because it ignored the notice invoking arbitration. So I would say it's very important, very critical that every correspondence which comes to you is obviously not merely the notice of arbitration, but every correspondence which is coming to you, either from the arbitral institution, from the arbitrators, or from the counterparty, is obviously responded within the timelines which have been provided.
Moving from invocation to document management and for your evidence purposes, Chakrapani, how important is it to have all your evidence and documents in place prior to filing your statement of claim?
Right. So it's we all know that, but it's good to summarize again. And in fact, before that, I just wanted to start with a live thing that just happened. Before coming to this, I had a call with a client who wanted to invoke an arbitration, which is pertains to an old contract, but it will start now. And in my usual way, I started telling the client that, look, you need to gather this document, you need to do this, let's start preparing. And I was very pleasantly surprised with the response that I received. Said, sir, we have kept everything related to this document, catalog, indexed, and all in a PDF form ready for you. I will be sharing the link. I was impressed.
You are on mute, Chakrapani. You are on mute. No, we can't hear you. So before, let me right now, Ajay, come to you, and we'll probably Chakrapani will come back to you once your audio is sorted. Ajay, while at it, how important is to identify the right facts, fact witness? What are the considerations that you keep in mind when you are selecting a fact witness for your client?
So this again is a very relevant aspect of trial, because all of us, I can say, in our much younger days, were taught the first question to put to any witness on the other side was, when did you join the company? And the moment the answer was a date post the dispute or transaction, so that gave us a bit of confidence that this guy may not know the facts we can play around with it. But over the years, we have seen that, and of course, that was in an era where suits per se used to take a lot of time. Then, luckily, most of us were lawyers in '96 when the Arbitration Act came. The way arbitrations were really evolving that time, it still used to take a long time for the trial to reach. And an arbitration was like a 5-year window or 5-year horizon. So by the time you landed up at the stage of evidence, most of the times the employees were not around. And we always used to grapple with the clients, either with their finance teams leading those matters or legal teams as they grew, when we were also kind of growing as external lawyers, that who in the company will prove this fact of such a statement or such paperwork or such agreement. Then we realize, that obviously it is best to have somebody who was there, who had signed the contract, who was privy to the pre-contract conversations and how you arrived at a certain agreement, then when the issue arose. So ideally it has to be somebody who is literally a fact witness, who is a witness to that fact, either pre-contract, during contract, post-contract, dispute has arisen. So most ideal candidate will be somebody who's been there and has personal knowledge. And also, so that is a very obvious kind of answer we all know. But what do we do when the right employee is either not available, not in the employment, or he's just not willing to become a strong kind of a contender to be cross-examined? Then of course we go to the others who start saying, okay, these are documents which need not be proved because under our Evidence Act there are certain norms we all are aware of. Or he says, I am giving this evidence based on the documents and records available with the company. So that's about it. A third category we are seeing where sometimes legal officers of the company are being asked to become witness in arbitrations, which in my view is kind of difficult because most of the time they may not have personal knowledge. So again, anybody who does not have a personal knowledge may not be the best person to put out there for cross-examination. Giving your affidavit and evidence is not a problem, but to be cross-examined on certain factual aspects, it is best to have somebody who was there at the time, and that's how it should work, in my view. Thank you.
Thank you, Ajay. Chandramani, you want to finish what you were saying?
Yes, am I audible now?
Yes, yes.
Great. So apologies to all for that little bit of a technical glitch which I could not solve. So as I was mentioning that things have evolved a lot, and how important it is to have your evidence and documents in place, extremely important. It's absolutely the basis on which your entire case is going to be, whether you are a claimant or a respondent. You have to gather all your evidence, even though it is very famously said that arbitration does not follow the strict rules of evidence, etc., etc. But all of us here have experience, and we know that whether it is international commercial arbitration or domestic ad hoc arbitration, we need evidence. We need to discharge what is the burden of proof on us, whether if we are claiming something. And for that, we need documents. So to that purpose, we need to have all our evidence in place. As Ajay said earlier, identify and keep your witnesses ready so that you don't start scrambling for witnesses, etc. They may have moved on from organization. So you need to have that ready. Very important point that often we miss is that we don't make a list of privileged documents, because that comes in, if it is especially in an international commercial arbitration, it gets opened up, and then if you don't have your ready list of documents which you can claim privilege for, then that becomes an issue. So the best practice would be have all your evidence and documents in place beforehand or at the earliest possible. Identify your privileged documents so that during the case management meeting, privilege log can be created. identify and keep your witnesses ready, and engage the service of expert, as earlier speakers have said, at the very earliest when the claim arises or when you want to prefer your defense and counterclaim. So that's the summary, Rajesh. Over to you. Once again, apologies for this little bit of connection glitch.
So, Sanjeev, is it a mistake to determine arbitration strategy based on cost alone? How often do you see this happen?
So I would say alone, yes, but yes, cost would be a relevant factor. I think when you are either wanted to claim an amount or you are defending a claim, obviously you look at all the things. You look at a kind of cost benefit analysis. What are your chances of success? You have the right kind of an evidence. Do you have the witnesses who can support that kind of an evidence? Whether the contractual interpretation is going to be aligned with what your claim is. So there are quite a lot of factors which obviously one would look at as to whether it's a good claim or a bad claim. And obviously depending upon, and what's the value of the claim also. Obviously you really don't want to run a small claim with so much of firepower that the legal cost might be more than what is the claim you're going to get, merely on the sense that winner will get all the costs, but obviously you might not get the entire cost, you might get a truncated cost. So I would say yes, cost would be a factor, but as I indicated, there would be other factors which will go into the mix, on the basis of which you will devise a kind of a most appropriate litigation strategy as to how to run a dispute.
Thank you, Sanjeev. I think we have a lot of questions from the audiences. And now I'm going to take some of the audience questions. And Ajay, first question probably I'll reach out to you is, in your opinion, have Indian institutions for arbitration matured sufficiently to opt for India-based institutions? If yes, which India-based institutions should one opt for? It's a tricky one. Ajay. You have to be very careful answering this.
Fully loaded question from our colleagues on this webinar. Well, I have a view which I've expressed in multiple platforms over the years, that well, I'm not so sure, and don't hold this against me, any of you, that you see our mindset in the Indian context is very ad hoc based arbitration, and that mindset will need substantial changes at multiple levels, from the company side, in-house legal side, external counsel side, till we finally move on to the era of only institutional arbitrations. So while when we do advise clients for institutional in arbitrations which are having a neutral jurisdiction like SIAC, ICC or others, they don't have a problem. Most of our in-house legal friends on this call will appreciate that their management also doesn't create a issue that fine, you are accustomed Singapore SIAC, London ICC, Paris ICC, you can do that. But when it comes to India, they say, would we retain control on nomination of arbitrator? Answer is no, because at times you do contractually, at times it's up to the institution. So it's all varies on contract to contract, what the parties have actually agreed in their arbitration clause to do. So administration of arbitration by institution, psychologically, it comes as a jolt to most. When you say, oh, all right, choose an institution, the first question is, are they expensive? If they are internationally acclaimed, must be expensive. So why go that path? And on the other end of the spectrum is that, can you control cost? So choosing an institution, what I have seen, and this is purely my personal experience here, choosing an institution is based on the cost analysis which we have to provide to our in-house legal friends, which they have to take an approval from their CFOs or management, etc. So I feel we are yet to arrive, and we have a far way to really become kind of a arbitration bar which is purely on institutional arbitrations. And when on choosing an Indian institution, well, the choices are very kind of limited. So I would not comment on that one. Raj, I leave you to comment on that one. So I hope that answers to our friend who asked this question.
Thank you, Ajay. I think I'm sure.
Sorry, may I come in for a minute here?
Yeah, yes, please, Chakraman.
Yeah, so basically, what I wanted to say is I'm not getting into any controversial arena. But what I wanted to say is that some of the Indian institutions' rules are on par with international institutions. So feel free to choose and feel free to like go through those rules because most of these organizations are following the international best practices. That's I just wanted to add that one point.
So while I did, Chakrapani, why don't you take up the next question also, which probably is more of your alley. In Indian context, are there any alternate dispute resolution methods such as mediation? Then that can be combined with arbitration proceedings for effective resolutions. What are the statistics for utilizing this approach, and how much more or less effective is it, and in what types of disputes? Maybe you can give a very brief response to this because we are also running out of time.
Sure. So I will say, I will start with what I can't answer, and that is the statistics because for two reasons, these are many of these things are very private in nature. Like I may have done a dozen mediations, but I can't talk about them. And there is no agency compiling the data. So that data is right now sketchy and not available. Coming to the main question, it's extremely effective and it's getting better. Especially mediation or negotiated settlement are two areas which are really picking up in commercial space in India and internationally. We all know that after signing of the Singapore Convention on Mediation, mediation has been the buzzword internationally and in domestic arena as well. The courts have encouraged parties to mediate. We have some very celebrated cases on mediation which went through. Whether they succeeded or not is a different story. But on a smaller level, mid-sized disputes and even some of the complicated disputes are getting resolved through mediation. And that's one thing that the trend that we saw was started during COVID. So, and it has continued. Second related aspect is, if I understood the question correctly, is that in conjunction with arbitration, it works very well. So you can have med arb med or you can have arb med arb, which means that you can either try in an arbitration while parties are in arbitration with consent, they can move to mediation and come back to arbitration to get an arbitrated award, or the other way around. So it is definitely picking up. It is the way forward because we can't have one possible way of dispute resolution given the complexity and vast number of disputes and the pendency of matters in the court.
Thank you, Chakrapani. Sanjeev, maybe I'll take one more last question from the audience, and maybe I can request you to answer that because it's in the context of the seat versus venue. When a seat of arbitration is agreed between the parties, in that case, is the necessary is that necessary to agree on the governing law as well? Maybe you want to throw some light on this question.
So depends upon whether you're wanting the governing law of the contract or governing law of the arbitration. Because if you agree on the seat, then obviously you decide on the curial law also. So curial law gets decided, and curial law is the law of the seat. But obviously you can always have a different law which governs the contract. And it's always, my advice would be that not to keep anything to the imagination of either the arbitral tribunal or to the parties. Because if there is any kind of ambiguity or any kind of a vagueness, that is something which is obviously going to get thrashed out. And there would be two versions as to what that ambiguity means and why didn't the party put in what they should have put in. So my advice would be not to leave anything ambiguous. My advice would be to decide on the law of arbitration, the governing law, the seat, and I think it's just a 5 minutes job. Once you agree with the other side as to how you want the arbitration to be conducted, once it goes into the dispute, then in that particular case, I think you can just put it down. You spend so much of time, effort, and energy debating with as to what the parties meant because the contract is silent.
I think, thank you, Sanjeev. I think that's quite clarificatory to the question that was asked. So, if you were to take some of the key takeaways from this webinar, I think to my mind is that do put in a good arbitration clause, spend some time in drafting your arbitration clause, think about the clause through and through so that you know what you want, number of arbitrators, the seat, the place where you're going to execute the award, the kind of nature of the dispute that it's going to be. Do you need a specialized arbitrator? So keep all of these things in mind, think it through, don't be in a hurry to put in a arbitration clause without having spent some time on it. The easier way to do probably would be, if you're considering an institutional arbitration, probably pick up a clause which is provided in most of the institutional rule books and use those as the model clauses. That may make things easier, be it ICC, SIAC, MCIA, IAMC, whichever clause that you may prefer. So there are many institutions that are available. The other thing is also, from what the discussion is, that I think the legal teams are always ready. They need to get involved with business much earlier when the business team starts to see that there is a trouble brewing in a particular matter or a particular transaction. It will be important for the legal teams to get involved at that stage so that the documentation and the correspondences that are going through to the other side or to the counterparties are well reviewed and are legally in place, so that if it comes to invoking an arbitration or going into a dispute, you have your documentations in place. Also, ensure that your documents are kept properly through the entire period of your transaction, documented properly. Ensure that you have the right witnesses to give evidence at the end, because many times you've seen that while those who are actually performing a contract have left the organization, and there is somebody else who's going to come step into his place to give an evidence, and his evidence is only going to be based on the documents that were prepared or kept on record. So it's very important to ensure that your documentation is done so well that if somebody is even giving an evidence based on the documents, he's able to give a correct picture or a correct and true story to the tribunal. I think some of these are very key takeaways from this. Choosing a seat is extremely important, as Sanjeev and others have said. So be very, very mindful of choosing your seat, because that can, at the end of the day, break your arbitration. Because if you may have an award which may have come from a seat from where execution may be very difficult, or which may not be reciprocating in a country where you want to execute an award. So be very, very mindful where to seat an arbitration. I think with that, I would like to now request our IT team to just put in a quick poll. Thank you, Sanjeev, Ajay, and Chakrapani, for your thoughts, and were very insightful. Before closing, I would request all of you to take this poll and respond to our poll slides. In conclusion, let me thank you all. Finally, I want to thank all the audience and the attention that you've given to this webinar. I hope you found this webinar interesting and worthwhile investment of your time. We certainly enjoyed bringing this webinar to you, and hope you take something out of this webinar. You will also separately receive requests for your feedback on the webinar. Please take some time and give us your feedback. Your feedbacks are very important to us. We really take this feedbacks very seriously and try to improve in our next webinar. We will also, post the webinar, respond to some of the questions which we have not been able to take it up during the course of the webinar, and we will send a response to the parties on this question. Thank you for your attendance today, and we look forward to being with you again in the Inhouse Counsel Forum. Thank you all. Thank you.
Thank you, everyone.
Thank you, everyone. Thank you, Raj.
Thank you.
Thank you, Raj.